Today we are hearing arguments in the case of the Queen and Peter Adams. Can we please hear the counsel for the appellant?
The court will probably be aware that there is grave public concern about dangerous dogs. Over 200,000 people each year in this country are bitten by dangerous dogs. It is a matter of grave public concern. The legislation itself places considerable responsibility on the owners and the controllers of such dogs in public places.
In your submission that the statute is clear, could you please address the court on how the statute is clear, and clear as to what?
Yes, of course, my lord. The statute is clear in that there is no requirement for mens rea. There is no requirement for causation. There is no requirement for any assessment of fault. And there is no requirement for contributory negligence.
Do you think it was the intent of Parliament to enforce it literally, even in a case where it would outrightly lead to an unjust result?
I would submit that's absolutely correct. Certainly, the intention of Parliament, from my reading of the parliamentary debates, were, if anything, to make the application of the legislation even more severe.
There is a strong presumption of mens rea, is there not, Mr. Brenner?
With respect, Your Lordship, I do not believe that the case law in England supports that.
And are you saying that there is no possible defence in this case whatsoever?
My submission to the court is that which other courts, other than P.A. Robinson, have taken, that it's strict liability. You have a dog, you're in control of it, you bring it into a public place, and it attacks or injures someone. It is a logical, consecutive drafting of legislation.
Your Lordships, we are here today dealing with an offence which is, if found liable, punishable with 2 years imprisonment. Is it the intention of the law to put an innocent and diligent dog owner in custody for 2 years for an offence that is not his fault? It is the appellant's submission that it is not the wording of the Act to suggest that knowledge or apprehension of the dog's nature was required to establish a conviction under the legislation. And we, with due respect, humbly submit that even if this is the sole intention of the Parliament, the law should not be rigid. The law should be flexible, taking into account of the various possible circumstances, and above all, it must be just and fair.
Wouldn't it be impossible to convict anyone if we look at a defendant's state of mind? Because everybody would argue, I couldn't have known that my dog would be dangerously out of control. What would be your answer to this?
We are not looking only at the mens rea, but also the actus reus and the circumstances that goes with it.
How would you respond to the argument that the very act of bringing the dog into a public place has already caused or contributed to the prohibited event.
Your Lordships, an absolute liability rule in this area, irrelevant of a person's reasonable knowledge or belief, has the capacity to provide enormous unfairness. For the many, many dog owners in this country, it is vastly important that the onus lies with them as far as is physically possible to ensure that their dogs remain under control. However, if through absolutely no fault of their own, they are unable to do this, liability should not follow.
Thank you, Ms. Sayuti. Thank you, Mr. Brenner. The court will reserve its judgment into the future.